Principal and Agent, Business Law for Everyday Use, Alonzo Rogers Weed. Principal and Agent. What an agent is. An agent is one who has authority to act in behalf of another, his principal. To act here means to take steps causing legal liability. With a very few exceptions, anything which may be done lawfully may be done by means of an agent. Indeed, the greater part of business is transacted by means of agents. Since the agent's acts, as such, are really the acts of his principal, he may be a competent agent, though incompetent to contract for himself. Thus, minors and married women may be agents. The principal, however, must be legally competent to contract in order to be bound by his agent's acts. One person cannot, in the same transaction, act as agent for two different parties, or as agent for another and principal for himself, unless both principals know he is so acting, or his duty is simply that of a middleman to bring the two parties together. For example, an insurance agent cannot take out a policy for himself. An agent's duty is to obey orders and to keep regular accounts and vouchers ready at any time to show the condition of his principal's affairs. He is bound to exercise reasonable skill, diligence, and prudence in conducting his principal's affairs, and is liable to his principal for any neglect of duty. How agents are appointed. No one can lawfully act as another's agent without his consent. The principal must give his express consent to the agency, either orally or in writing under seal, or a consent implied from his treatment of the agent's acts, or from the relations of the two parties. Express appointment. Where an agent acts in accordance with the definite instructions of his principal, the principal's consent is, of course, apparent. An appointment in writing is always advisable, since it is less open to misunderstandings than an oral one. But authority to execute any contract which requires a seal to make it binding can only be given to an agent in writing, signed and sealed by the principal. For example, an agent with authority to sell land for A could not give a valid deed of it without an appointment for this purpose in writing, signed and sealed by A, unless the deed is signed and delivered in A's presence. Even if a principal should acknowledge that his agent had sufficient authority to execute a deed, probably this deed would not be binding on the principal, unless the agent's authority was given under seal. A vote to a corporation, however, is a sufficient authority for its agent to execute a deed binding the corporation. Implied appointment. If one allows another to act for him without interfering, an implied agency is created, and the principal is bound by the acts of such an agent. For example, the agent of an express company used to get a bookseller who occupied the same store with him to receipt for packages left when he was out. This practice was known to the superintendent of the company, and the company was held liable on a receipt signed by the bookseller. So too an implied agency may be created in case of great necessity. Thus, in case of a railroad accident, the conductor would have an implied authority to bind the company for the physicians who he summoned, or the master of a vessel, in case of disaster, could bind the owners by contracts made to save their property. Any act done by one in the name of the another may be afterwards ratified by that other, thus making himself liable as for an act of an authorized agent, even though at the time the agent was acting without authority. But the principal must have a knowledge of all the facts connected with the agent's act in order to make his ratification good. This ratification need not be made expressly, but may be inferred from the principal's conduct or from his silence. A wife can bind her husband only as his agent, acting with his express or implied authority. She has a presumptive authority to purchase necessaries for herself and family, unless her husband himself provides them, but he may direct how and where these should be bought. If they separate through the husband's fault, the wife carries with her this implied authority to bind him for necessaries, and he cannot relieve himself from his liability by advertising that he will not pay. But if the separation happened through her fault, she will lose her authority. A father is bound to support his minor children, and is therefore bound by their contracts for the necessaries of life. But the child's authority is more strictly construed than is the wife's, and if the father has made provision, this implied authority is gone. If a boy is driven away from home, he still has this implied authority. But if he leaves of his own accord or is given this time, he probably loses it altogether. A father is not bound to support his stepchildren, but if he does, then they are in the same position as his own. A father is not liable for injuries done to another or to another's property by his children unless he commands them or afterwards approves of their acts. A father has a right to his minor children's services and earnings unless he emancipated the child. He may sue for loss of service if the child is injured by third persons, but the child must be old enough to render some service. Otherwise, the father has no grounds on which to base his claim for damages. Extent of an agent's authority. Within the limits of his employment, the acts of an agent are, in legal effect, the acts of his principal. But as soon as he goes outside these limits, he ceases to represent his principal. If he is employed to manage some department or interest of his principal's business with at least apparently discretionary powers in conducting the affairs of that part of the business, he is a general agent. Any act of his which is fairly within the authority usual to his position will bind his principal, even though contrary to the principal's instructions. For example, managers of branch stores, agents of corporations, etc. Even clerks in stores may be general agents who sell according to the authority given them. But if he is an agent of some particular purpose without any apparent discretionary powers, then any act done outside the actual authority given him will not bind his principal. Anyone dealing with such an agent should ascertain the extent of his authority or take the risk of being able to hold his principal accountable. Thus, a drummer whose duty is to solicit orders for goods has no authority to warrant them unless that is a custom with that particular class of goods. If an agent is acting under written instructions from his principal, and this fact is known to the party with whom he deals, his authority will be strictly limited to these instructions. The agent is bound to do personally the duty for which he is employed, unless it becomes necessary from the nature of the business, or is the general custom in that particular kind of business to employ subagents. But he is personally responsible for his subagent's acts. A principal's liability to persons dealing with his agent. As already explained, the agent must act within the authority given him to render the principal liable at all to a third person. Thus, authority to collect a debt is authority to take cash only, or authority to sell is not authority to give credit. In any written contract under seal, unless the principal and not his agent appears as a contracting party, and unless the deed is acknowledged in his name, he can neither be held liable on it nor enforce it himself. Where negotiable paper is signed by an agent, the principal must clearly appear by the face of the instrument to be the party promising in order to be held liable on it. For example, a note signed A. B. Agent would not bind the principal, the word agent being considered merely a description, where it's signed A. B., agent of C. D. It will probably not bind C. D. But if A, B promised in the note or signed himself, agent for CD, or as agent of CD, CD would be liable. In all other simple contracts, however, the principal's name need not appear at all. Here it is simply a question whether the agent acted within the scope of his authority or not. If he did, then the principal becomes the real contracting party, and his rights and liabilities are fixed accordingly. As a general rule, too, the principal is liable on and can enforce such contracts even though the person dealing with the agent did not know who his principal was. If, however, the other party, not knowing that he was dealing with an agent, had a claim against the agent, he would set this claim off against the claim of the principal founded on the agent's act. Or if the other party should make a payment to an agent, honestly supposing him to be his own principal, the real principal could not make this other pay a second time. But if the other party knew he was dealing with the agent of somebody, he would make a payment to such an agent with the risk of having to pay again to the principal. If the agent acts with apparent but not real authority, of course the principal is not bound by such acts, nor does he gain any rights on his side. But he may ratify these acts, and he then assumes the position of principal. A principal is liable for any fraud, deceit, negligence, or willful misconduct of his agent, committed while acting fairly within the limits of his agency. A very common example is that of a railroad accident, caused by the carelessness or misconduct of the company's employees. The company is liable for the injuries to the passengers. But there is always a practical difficulty in finding whether the act causing the injury is within the scope of the agent's employment. If it is not, even though committed with an honest intention to further his employer's interests, the principal is not responsible. An agent's own liability for his acts. Where a contract clearly shows the intention of the agent to bind his principal, generally he cannot himself be held liable on it. But where a contract is made in his own name, even though agent is added, he will be personally liable. He will also be responsible if the party dealing with him had reasonable cause to believe him his own principal, or if there is a general custom to hold a party making such a contract personally liable. Of course, if he is his own principal, or if he acts without authority, he will be liable. A contract might perhaps be made which would bind neither the principal nor agent if the agent acted under an honestly mistaken authority. If an agent does not disclose his principal's identity, a party dealing with him may choose between him and his agent, but can only enforce his claim against one of them. On the other hand, wherever an agent would be held liable on a contract, he could probably himself enforce it against the other party unless his principal had done so already. The liability of employers. As already seen, the relation of principal and agent is created by contract, either express or implied. Accordingly, where there has been no previous agreement as to pay, an agent is entitled to reasonable compensation. If an agent, while honestly attending to his principal's apparently lawful business, injures some third person, he must be indemnified by his employer for any damages recovered from him by this third person. He must also be indemnified for expenses or loss fairly incurred in the discharge of his duties. Thus, if A orders one of his employees to cut trees on a certain piece of land, apparently owned by A, and it turns out that B owns the land, and B prosecutes the employee for trespass, the employee can claim of A the amount of damages recovered from him by B. Probably more litigation arises at the present time over the question of an employer's liability for accidents caused by the negligence of his employees than from any other one source. It follows from statements already made that if the accident is caused by the negligence of an employee while acting within the scope of his employment, his negligence is his employer's negligence, and the latter is liable for injuries occasioned thereby. Whether the employee was so acting is often a delicate question of fact, dependent on the peculiar circumstances of each case. Towards his own employees, an employer's liability is not so broad. An employee is assumed to know and accept the ordinary manifest risks of his employment. So also he cannot make his employer liable for injuries caused by the negligence of his fellow servant. But as to just what constitutes the fellow servant in a given case is often a difficult question. For instance, an engineer and a switchman on a railroad have been held to be fellow servants, while an engineer and a conductor and a brakeman and a car inspector have been held not to be fellow servants. On the other hand, an employer is bound to use ordinary care in selecting employees competent for their position and to furnish safe and proper machinery, and is nonetheless liable if he leaves these matters to the care and superintendence of others. Notwithstanding an employee's assumption of the risks of his employment, if he is injured by defects in machineries of which he had no knowledge and no reason to know, or by defects of which the employer or his superintendent had noticed and neglected to remedy, the employer is liable. The tendency of recent legislation is to extend still further this liability for an employer so as to do away with his defense of fellow servant and implied assumption of the risks of employment. Some special kinds of agents, attorneys, in fact. They are agents usually formally appointed to execute deeds or to assume some of their principal's general powers. The writing appointing them is called a power of attorney, and if it is to execute deeds, it must itself be given under seal. A power of attorney should give specific instructions and is strictly construed by the courts. Attorneys at law. A lawyer's duties are specifically defined by statutes in most of the states. In general, however, their duties are to give advice to their clients and to appear for them in court. They are really judicial officers sworn to uphold the laws of the land and to look after the client's interests honestly and faithfully. Brokers. A broker is one who negotiates for others the purchase and sale of stocks and commercial paper or of other kinds of property. He is not strictly an agent for either party in the sense of acting in their place, but he is generally a middleman or go-between to bring the parties together. He is entitled to his commission as soon as he finds parties prepared to trade with each other, and if no amount is agreed upon, he can recover the usual commission for each such work. The term broker is used so loosely that this definition may not apply to many who call themselves brokers. Commission merchants or factors. They are persons or firms to whom goods are sent by manufacturers for sale. They may sell in their own name or in the principals as they choose, and are personally responsible on their contracts. They have possession of the goods sent them for sale and a lien on such goods in their hands for their commissions or any balance due them from their principals. Certain factors called del credere or guarantee factors for an extra commission warrant that their principals shall receive the goods for the goods sold, whether the purchaser pays or not. Consequently, if the purchaser does pay, the title to the money passes at once to the principal. Auctioneers. They are usually the seller's agent and hold a similar legal position to factors. They have a special property in the things to be sold, and consequently a lien on it and the purchase money, if authorized to receive it for their commission and other charges. Termination of an agency. An agent's authority can be recalled at any time before it has been exercised, unless it is coupled with an interest. Thus, if a power of attorney was given for the sale of certain land in consideration of money advanced by the agent to the principal to be secured by the sale, such an authority is coupled with an interest and cannot be revoked. The appointment of a second agent to take the first agent's place would act as a revocation of the first agent's authority. The death, insanity, or bankruptcy of a principal would revoke his agent's authority, but if an agent had no knowledge of his principal's death, his authority is still sufficient to render the estate liable. An agent may renounce his authority at any time of his own accord, subject to a claim for damages if his principal sustains any injury by this act.